Crime is wickedness. Crime is greed. Crime destroys families. Crime divides nations.
Take her to the Littleton police station and the attorney can take her to the court. This is already a courtesy and an exception to what ordinary citizens are afforded. There's not a single fact set out as why the future arrest will be unlawful, seemingly because there is a weak case made out. Yet the applicant does not know what case has been set out, and this is pure speculation. I can make no finding on such speculation that there will be an unlawful arrest or that there is a weak case. These facts cannot underpin urgency. The respondents argued that it would not be competent for this court to interdict an arrest. I'm in full agreement with this submission. Not on the facts presented, but more importantly, a court has to take cognizance of the fact that if the court grants such an order, the floodgates will be opened. Every suspect will be in a position to approach a court on an urgent basis, setting out on speculation that there is a weak case against it and interdict an arrest. Any suspect would merely have to set out in a founding affidavit that arrest in future will be unlawful. The whole criminal justice system will fail and will be controlled by suspects. This applicant has been ensured that Section 40 will only be utilised if she does not present herself to the police station. The applicant has failed to do so for 2 weeks. The fact that Section 40 will only be utilised if she does not present her to the police station is in complete compliance with the standing orders, which sets out that arrest should be a last resort. I was referred to the matter of President of the Republic of South Africa versus Zuma and others, 2023-11 SACR 610, Gauteng Division, paragraphs 8 to 10, that it would not be an overreach for this court to interdict arrest, but a bench exercising judicial oversight, if I should interdict the arrest. The matter is not comparable and does not sway me that I'm entitled to judicial oversight of this nature. I am therefore also not granting this order. Although I do not address all the issues raised, it does not mean I did not consider it. No remedy is pertaining to the search and seizure. The respondents deny the media leaks emanate from their officers or agents, but in any event, no remedy is sought pertaining to any leaks. In the applicant's affidavit, there are a variety of emotive garnishing, on which a court unfortunately cannot take cognizance and make factual decisions on that. However, even if the court finds that the matter is not urgent, the court must still make sure that there is substantial redress in a hearing in due course. Not in the founding affidavit of this application or in the main application is any fact set out. This requisite in terms of Rule 612B and the Practice Directive is not at all addressed in the founding affidavit. But even if I consider it, despite the applicant setting out any of these facts before me, even if I should consider it, then also pursuant to a question by this court, whether this court would not be deciding already the matter as it seeks the same relief pertaining to arrest in the main application, counsel for the applicant strongly argued that that court would make a final ruling, as this is just an interdict. In that case, the applicant will have substantial redress in a hearing to follow. As for the cost must follow the result. Both parties asked for cost, including the costs of 2 counsel. According, the application is struck from the roll. The applicant is to pay the costs, including the costs of due counsel. The court will adjourn.
Ons mama